Um, so good evening all, and thank you for joining this Zoom call organized by We Democracy. My name is Orit. For those who do not know us, We Democracy is a grassroots community of Israelis and Jews living in the UK. We were established a year ago with the aim of supporting the pro-democracy movement in Israel and have organized demonstrations and events in London, Cambridge, as well as Oxford, all in solidarity with the protests in Israel against the judicial overhaul. We continue to support the protests in Israel, who unfortunately are also including families of the hostages at the moment, and we call for the hostage deal and elections now, amongst other things. The idea for today's session came after a fascinating discussion that took place a couple of weeks ago on one of our WhatsApp discussion groups. And the subject of occupation, which is the subject of today's Zoom, was always in the background, but prior to the 7th of October, our focus was always on stopping the judicial reform. And we used to say that let's focus on making sure Israel remains a democracy before we have time to deal with other matters like occupation. Following the horrific events of the 7th of October and subsequent war, it became impossible to continue to ignore the elephant in the room. People were talking about occupation, they have questions, and many of us seem to suffer from gaps in our knowledge. We are lucky that two of our members have volunteered to share their expertise and take a deep dive into this complicated issue. I'm happy to introduce Dr. Ruvi Ziegler, who will explore legal questions arising from the armed conflict in Gaza, particularly pertaining to the occupation. Ruvi is an associate professor in international refugee law at the Reading University. He is a research associate of the Refugee Studies Center in Oxford and a senior research associate of the Refugee Law Initiative at the School of Advanced Studies in London. His expertise lies in international refugee law, international humanitarian law, and questions of political membership and participation. Today's session will take about an hour and a quarter. Ruvi will start with a presentation, and then there will be time for questions, which I invite you to share on the screen with us. You can write your questions in the chat, or you can raise your hands and ask them when the time is right. But please wait for Ruvi's presentation to finish before asking those questions. Please also make sure you are muted throughout the presentation. We are also joined by Dr. Ofer Shinar Lebanon, who is a former lecturer of psychology of the Israeli-Palestinian conflict and on international law at the Hebrew University. Ofer was a research fellow at the International Center for Transitional Judicial Justice and head of research at the Bereaved Families Forum. Both Ofer and Ruvi will do their best to respond to as many questions as possible, but obviously keep in mind that this is a big and complex subject, and while we cannot cover the entire topic over 2 sessions, we hope this will be a good start. So Ruvi, the floor is yours, or in our case, the screen is yours.
Thanks very much, Orit. I also want to acknowledge Jenny, who's kind of done a lot of work in organizing this session and offer session, and I know can't be with us tonight, but is eager to watch this afterwards. And please do share the recording once we've made it available with others as well. So what I will be doing is I'll be sharing my screen, so hopefully everyone can see the presentation in full just in a second. And I've titled this Occupation Gaza and International Humanitarian Law. And what I want to do is, after providing a little bit of a broader legal context for the specific questions I'll be dealing with, namely those involving occupation, I'll be going through essentially 4 interrelated but distinct kind of questions. The first is, when does an occupation begin and when does it end in international law? And what I want to do here is present what is often characterized as the traditional approach to international law that applied in the past, which broadly presented the same conditions for the beginning of an occupation regime as the ones that apply to its end. And then I want to talk about what's referred to as the functional approach to occupation, which in colloquial terms can be summed as authority implies or means responsibility. And it's the functional approach that has been most prominently applied to the occupation or to the question of occupation of the Gaza Strip between 2006, so 5 towards 2006, and the time before October 7th. So to get to that second stage, the second relevant element to our discussion is the question, was and is the Gaza Strip occupied by Israel? And here the answer in the period between 1967 and the unilateral disengagement from Gaza in 2005 was unequivocally yes. It was, in fact, the answer given by the Israeli authorities themselves in legal ordinances. The question then became much more complicated, as I've alluded to, in the period between the end of this engagement and October 7th. And the question is more complicated still since October 7th, and that has ramifications. So that will take me to the third question that I want to explore. How and why does this matter now? That question of whether Gaza is or isn't occupied. And fundamentally, it matters for the distinction, not just in international law, but often in law more generally, between negative obligations that Israel may have under general international humanitarian law and the positive obligations, the obligations to ensure certain provisions that follow from being an occupying power. And what I want to do here is also discuss a little bit, for those who are unaware, the case that is currently pending before the Israeli Supreme Court, sitting as a High Court of Justice, brought by several Israeli human rights organizations, that is pressing precisely this point around the humanitarian, what I would define as catastrophe that is unfolding in Gaza. And then the final thing I want to do, which is to kind of take us a bit of a zoom out of Gaza into the wider elephant in the room, that is the occupation writ large, and in particular, the now nearly 57-year occupation of the West Bank and East Jerusalem, and to highlight here something that, again, I think, unlike the genocide case before the International Court of Justice, which has received great prominence in Israeli media and in the general international media, the second case that the International Court of Justice is hearing has, I think, received very little attention. But in some ways, it's not less important, perhaps even more important for the long term. And that is a case or an advisory opinion that the International Court of Justice is currently deliberating on the legality of Israel's prolonged occupation in the West Bank, East Jerusalem, and debate depending on how we consider it in Gaza as well. And that could have profound implications as and when that advisory opinion is rendered. So I'll try to end there, and there. Obviously, happy to answer questions, as Arita suggested, on any of these dimensions or on things that branch out of them to the best of my ability. So before I delve into that first question, I just want to offer a bit of a broader legal context. And the broader legal context is the following. There is often, very naturally, for most of us, a conflation of two separate questions. The question of who is justified in engaging in conflict or in war, and the question of how you behave in that conflict. We tend to instinctively kind of think, if someone is the aggressor, then they should be permitted less than if somebody is acting in self-defense. And in international law, those two questions are analytically and legally distinct. So the question of how Israel is allowed to respond to the attack on October 7th is separate from the question of whether that attack was legal or illegal, and whether Israel had a right to self-defense in respect of that attack, given that it emanated from Hamas, a non-state actor, so not from another member state of the UN, and that it potentially emanated from an area under occupation, the Gaza Strip. So that question of whether Israel acts in self-defense within the meaning of international law is one that is hotly debated on the international scene, but is entirely separate to the question of how it behaves in conflict. And how it behaves in conflict is regulated by a body of law referred to as international humanitarian law. Now, perhaps to make this come to life, think, for instance, about the war in Ukraine, right? And there's very little doubt, I imagine, for the people on this call, and I would say more broadly globally, that the war in Ukraine started with Russian aggression on the 24th of February, 2022. And that Ukraine has a right to self-defense in the context of that conflict. But that doesn't change the question of how you behave in the conflict itself. The rules that apply both to Russia, even though it's arguably the aggressor, and to Ukraine, which is arguably defending itself. And those rules in international humanitarian law are non-reciprocal. What that means is, and this is very critical because I think in the Israeli discourse, but more broadly, there is often, I think, an assumption that because Hamas is quite flagrantly violating almost any rule of international humanitarian law, and I'm perfectly happy to be on record saying that he does in almost every activities that it undertakes, that somehow exonerates or allows Israel to divert as well from the laws of armed conflict or international humanitarian law, because otherwise it somehow creates an unfair balance. And the reality is that international humanitarian law very explicitly does not create that reciprocity, unlike some other areas in international law and areas in domestic law as well. We can think about contracts where we sign a contract and often our behavior will depend on the other side honoring that contract. That is not how international humanitarian law works, because the focus of international humanitarian law is on protection. So if the other side, if the adversary is, for instance, deliberately targeting civilians, as Hamas obviously did on October 7th and since, that doesn't allow Israel to deliberately target civilians, because the consequence of that would be that civilians on both sides would be exposed to violations of international humanitarian law. So I just want to set this in context, because I think it matters to how we understand also Israel's obligations, potentially as an occupying power in the Gaza Strip. The fact that Hamas may be behaving in ways that breach its obligations as an actor in this conflict, in this armed conflict, does not absolve Israel from upholding and observing its obligations. And I think the final broader context point I want to make is that in this armed conflict, there may very well be violations of the laws of armed conflict that would amount to war crimes. And that is in addition to questions that we all know are arising in relation to genocide, to crimes against humanity that potentially were committed on October 7th, and indeed to that crime of aggression and the question of self-defense. And those questions of international crimes are ones that the International Criminal Court is in an active investigation of. The reason for that investigation is because the state of Palestine has acceded to the Rome Statute of the International Criminal Court. That is the reason there can be investigations in relation both to Israeli actions, but also in relation to Palestinian actions that have occurred on October 7th and ever since. In other words, it's because Palestine decided to join the International Criminal Court, whereas Israel hasn't, that the actions undertaken by Palestinian individuals, or the actions undertaken in the Gaza Strip, which is considered part of the Palestinian territories, that those actions are potentially subject to the International Criminal Court's jurisdiction, and that we may end up seeing, and this recording may last for some time, so I'm certainly not going to be making predictions, that we may end up seeing in this conflict arrest warrants against Palestinians or Israelis or both. So this is in terms of the broader legal context, and I now, from that one, to delve specifically into the question of occupation. So the traditional approach to the question of occupation is grounded in a treaty that is now more than 100 years old, the Hague Regulations from 1907. And this is, of course, a time when we virtually saw wars occurring between states, with ordinarily being declared as wars, and with militaries crossing a territorial border to another state and establishing themselves in the territory of another state if they were to occupy a territory. And so perhaps it's not surprising that the language of the Hague Regulations is very territorially bound. So the Hague Regulations say a territory is considered occupied when it is actually placed under the authority of a hostile army, that is an army that is not your army and is not an army you have invited to come in and assist you. And the context of the Hague Regulation said an occupation extends only to the territory where that authority has been established and can be exercised. Now, those conditions have led to a traditional understanding of occupation, starting with three cumulative conditions. So you need to have the armed forces of a state physically present in a foreign territory without the consent of the local government in place at the time of the invasion. We need to have the government that previously was present there incapable of exercising powers because of that unconsented presence of foreign forces. And in turn, the foreign forces themselves need to be in a position to exercise authority instead of that local government. So if we cast our mind back to 1967, in those 6 days between the 5th and the 11th of June 1967, Israel occupied the Sinai Peninsula, the Gaza Strip, the West Bank and East Jerusalem, and the Golan Heights, respectively from Egypt, Jordan, and Syria. And in all of those cases, all of those conditions were met. It brought its own forces into those territories. It displaced the local government, whichever it was in those places, and it started exercising authority in those territories. And indeed, it issued the relevant documentation to indicate that it now holds control over those territories. And so the question is, do those conditions of starting an occupation mirror the ones of ending one? In other words, is it enough for one of those conditions to not apply, for instance, to no longer have physical presence, for an occupation to fully end? And here, I think it is fair to say that in the times of the 1907 Hague Regulations, the answer probably would have been yes. But as times progressed, and particularly as technology and ability to control territory, not just on the ground, but also from the air and from the sea, and indeed electronically or technologically, the position had to become more nuanced. And the case study of Gaza in some ways became the case in point, as I'll try to illustrate in a few minutes. So the International Committee on the Red Cross which is the guardian or the custodian of the Geneva Conventions, the main body of law that applies to the laws of armed conflict, in a document dating back to 2015, has made the following, I think, very prescient point in relation to this question. It says that in general, that maxim that I've just described applies. In other words, we expect an occupation to end when there's no longer physical presence on the ground. That is what happened when Israel vacated the Sinai Peninsula following, for instance, the peace agreement with Egypt. But there are cases which they describe as some specific and rather exceptional cases where foreign forces withdraw from occupied territories, but they retain key elements of authority or other important governmental functions of the sort that are usually performed by an occupying power. In those circumstances, the law of occupation may continue to apply within territorial and functional limits of such competencies. And I will illustrate that later when we think about Gaza. So what the ICRC goes on to say, it says, despite the lack of physical presence of foreign forces, the retained authority may amount to what we would consider to be effective control for the purposes of the law of occupation. And that is why we define this as a functional approach. In other words, we think about the specific functions that are being performed, and the question whether the type of control, the type of authority that you exert over a territory and a population allows you to continue to operate in that area. If it does, then if you are able to exert authority, you are held responsible for the way in which you exert that authority. And the test ultimately is the extent to which foreign powers exercise governance functions that were acquired when the occupation was undoubtedly established and ongoing. And the context of Gaza is, of course, one where Israel was undoubtedly the occupier from 1967 to 2005, and in the space of that period has established all sorts of infrastructural, in particular, dependencies of that territory on its own territory that render it in a different position than any other country in relation to the Gaza Strip, right? And the ICRC finally says this functional approach permits a more precise delineation of the legal frameworks that apply to situations where it is difficult to determine with certainty whether an occupation has ended or not. And so we need to take into account the extent of authority retained by foreign forces rather than just focusing on the means by which it is exercised. So, and they finally say, rather, that indeed, when you've got a territory that is contiguous with your own territory, then not only are you able often to exercise remotely control over that territory, you're often also able very quickly to reestablish full authority. And indeed, I would argue that is what we see now, at least in parts of the Gaza Strip. And here you can think about an analogy. You can think about the US and the UK invasion and occupation of Iraq, thousands of miles away from those two countries. Obviously, once you have left those territories, to reestablish authority becomes much more difficult than if that other territory is quite literally on the other side of the border, on the other side of the barrier, right? So how does all of this translate to Gaza, right? So as I said, between 1967 and 2005, there was clear occupation. There was an ordinance of the IDF taking control, Ordinance number 1, issued on the day the IDF forces have established their presence in the Gaza Strip, taking it over from Egypt, which in turn was the occupier there from 1949 to 1967. It never annexed that territory. when the disengagement happened, when Israel evacuated all of its settlements and military bases from Gaza, it issued an order regarding the end of military government. That happened on the 12th of September 2005. And only 3 days later, the then Prime Minister Ariel Sharon gave a speech in the UN General Assembly where he said, what we have just undertaken represents the end of Israeli control over and responsibility for the Gaza Strip. In other words, we are no longer responsible, we left. The difficulty is that that departure was by no means complete. And the first reason for this was actually a legal reason, that however unilateral and uncoordinated, and I would argue deliberately so, the disengagement from Gaza was with the Palestinian Authority, it made no difference to the applicability of the Oslo agreements that were signed between Israel and the PLO and that have established the Palestinian Authority as one authority that was intended to apply to both the West Bank and Gaza as one integral territory. The Oslo Agreement remained then and remain today the framework which protects Palestinian institutions. And Israel at no point since the disengagement from Gaza thought to dismantle or repeal the Oslo agreements. Obviously, if it did that, it would have had in the West Bank to overtake all of the responsibilities that the Palestinian Authority exercises in the West Bank over education, over health, over welfare, over policing, etc. It doesn't want to do it, I think, probably. And as a result, it couldn't dismantle Oslo, and Oslo refers to Gaza as part of the Palestinian territories. But this isn't the only point. This is, you might say, a technical legal point, albeit I think a very important one conceptually. The real point is the reality of control that Israel continued to exercise over Gaza in the period before October 7th. So Israel, let's just recap some of the things that Israel was doing. It maintained control over the right to enter and exit from Gaza's territorial waters and over the extent of these waters. We all remember the flotilla incident. We now, I think, are potentially going to see flotilla number 2 coming from Turkey. But that happened in 2010, and that was an attempt to break what was deemed to be a siege over the territorial waters of Gaza. Israel exercised full control over Gazan airspace. Israel controlled over the years, because of that dependency on Israeli infrastructure, essential products and services, including electricity, fuel, and water. And indeed, many of those were cut off immediately following October 7th. And the fact that they were cut off demonstrate that they were under Israeli control. Israel importantly controlled the population registry of Gaza, so effectively preventing people from relocating within the Palestinian territories to the West Bank and re-registering there. It collected taxes that were owed to the Gazan authorities, in particular around imports. And it imposed, as some people will know, effectively a no-go zone, a buffer zone around the edges of the perimeter of the Gaza Strip, which amounted to about 17% of the Strip's territory. And so in respect of all of those things, Israel behaved differently towards Gaza than it behaved towards the Sinai, than it behaves, we can say, notwithstanding occasional aerial bombardments, towards South Lebanon, from which it unilaterally withdrew in May 2000. It behaved towards Gaza as if it's partly in, partly out. And indeed, that partly in, partly out attitude was reflected in the fact that Israel occasionally made incursions into Gaza. We all remember many of those incidents. And so to a large extent, some people say the functional approach, the ones that I've described by the ICRC, was something that was created for Gaza. And that may be factually true. It may be that prior to the Israeli-Gazan situation, there was no need to try and reconceptualize the law of occupation, because occupation was quite a straightforward case. You were either in or you were out. The Gaza Strip was a complicated case, and it necessitated a more nuanced and complicated answer. And at least my own view is that that functional approach was the correct view to take. It is the view that virtually every international institution that has been looking at the question of Gaza, both on the UN level, but also on other levels, the EU level, and human rights bodies have taken as well. So this was the reality pre-October 7th. Now, October 7th, as we know, has led to Israeli presence in Gaza, in different parts of Gaza, at least an attempt to displace Hamas, certainly over ground, from being able to operate. And there is no doubt that prior to October 7th, Hamas did exercise governmental functions in Gaza in certain areas in relation to what you would consider to be ordinary civic functions. Hamas was the government of Gaza. So the functional approach that I've been referring to would not have suggested that Israel had full control over Gaza, that he was expected to provide education services or welfare services or health services to the whole of the Gaza Strip. Nobody would argue this, because Hamas was exercising those functions either directly or via other bodies. And we know UNRWA had a great and retains a great presence in the Gaza Strip in relation to many of these functions. But since October 7th, the reality has changed, and Israel is present in one way or another in different parts of the Gaza Strip. And what that means is that in addition to the negative obligations that Israel has, I would argue it also has positive obligations in the Gaza Strip, and that matters for the contemporary discussions around the humanitarian catastrophe in Gaza. So let's start with the negative obligation. So the negative obligations are regulated in the Fourth Geneva Convention in Article 23, where it says that one must allow, or shall translate into must allow, the free passage of medical and hospital stores and the free passage of all consignment of essential foodstuff, clothes and tonics that are intended for children, for expected mothers, and for maternity cases, and that it is possible for that to happen under the supervision of Israel, if Israel wishes to exercise it, but that cannot be a basis for denying the entry of those consignments. And the additional protocol to the Geneva Conventions very explicitly says that parties to the conflict shall allow and facilitate rapid and unimpeded passage of all relief consignments, of equipment, and of personnel, even if it is destined for the civilian population of the adversary party, that is the other side. So this is prior to even having an occupation, even in a state where you are still in active combat. Those are negative obligations that the state has. And the context in which this is relevant for crimes, or for potential exercise of crime, is particularly relevant to the crime of starvation, which is a crime under the statute of the International Criminal Court, the Rome Statute, where it says starvation of civilians as a method of warfare is prohibited, and the destruction of infrastructure that is vital for the survival of the civilian population is similarly prohibited. So I won't go and read the full provision, but that is the gist of that provision. So the Rome Statute says intentionally using starvation of civilians as a method of warfare by depriving them of objects that are indispensable to their survival. That includes impeding relief supplies as provided for under the Geneva Convention. So the negative obligations are undoubted, right? They're irrefutable, and those are the reasons why back in January 2024, this year, when Israeli presence, certainly in the north, was not as well established as now, the International Court of Justice very clearly indicated as one of its provisional measures the immediate and effective measures to enable unimpeded humanitarian and urgent humanitarian assistance and basic services to Gaza. But, and this is where I return to the question of occupation, occupation arguably means not just those negative obligations, but also positive obligations to provide for the population at hand. And this is very much grounded in another provision of the Hague Regulation. So after saying we've got occupation in Article 42, the Hague Regulation proceeded to saying what is often referred to as the constitutional provision of the Hague Regulation. It says that once the authority of the legitimate power having in fact been passed into the hands of the occupant, in this context Israel, the latter shall take all measures in their power to restore and ensure public order and safety, and that is then translated into restoring ordinary life in a territory that previously was under serious combat. And this, I think, is the context in which we need to understand the case that the 5 human rights organizations, Gisha, Hamoked, Physicians for Human Rights, the Association for Civil Rights in Israel, and Adala, brought in March, at the end of March, before the Israeli Supreme Court, sitting as a High Court of Justice. And that case is now pending. There was a very prolonged hearing of this case on the 4th of April this year. And what they demand in this petition is to allow unhindered access of humanitarian aid agencies to Gaza, but also to act in accordance with Israel's obligation under the law of belligerent occupation, by itself supplying humanitarian aid to the civilian population. And as I said, this case is still pending, so it's unclear what the Israeli Supreme Court will be holding. But what the petitioners are relying on are the positive obligations that are explicitly provided for in the Geneva Convention. So whilst the provisions I spoke about earlier were about negative obligations, when you've got an occupation going, the Geneva Conventions say, to the fullest extent of the means available to it, the occupying power has the duty of ensuring, right? Ensuring, not just preventing, the food and medical supplies of the population. And it should in particular bring in necessary foodstuffs, medical stores, and other articles if the resources of the occupied territories are inadequate. And we all know that, for instance, Gaza did manage to manufacture large parts of its food supplies before October 7th, but that many of those infrastructures were destroyed. Now, some of them, and this is, as I said, a separate question, some of them may have been destroyed in active battle. The destruction per se may or may not have been a war crime, but that is separate to the current reality. The current reality is that those infrastructures do not exist to the same extent. And so if Israel is present, and that is particularly true about the north of the Gaza Strip, then it must, if it is unable to, if the population is just unable to produce those, and is unable to simply rely on aid coming from outside the Gaza Strip, then Israel has a positive obligation to supplement whatever is coming from outside with its own humanitarian supply. And similarly, the Geneva Conventions say if the whole or part of the population is inadequately supplied, the occupying power shall agree to relief schemes on behalf of that population and facilitate them. So the whole context of, for instance, the terrible event of the killing of the 7 workers of the World kitchen program, right, a few weeks ago, that was a convoy that was brought into the Gaza Strip as part of those relief operations. My fundamental point is that Israel, it's not sufficient for Israel to say at this point in time, we would allow any aid that comes in or that comes to the border to be let in. Israel has to monitor actively the situation inside the Gaza Strip, and if there are inadequacies, it actually has a positive obligation to fulfill them itself. So not simply to rely on international aid, but also to act itself. So I want to just highlight very briefly what Gisha is saying in their petition to the Israeli Supreme Court. And I think that's important also for Israelis on the call, because I think that picture as a whole is quite a troubling one, and is not one that I think certainly the Israeli media is portraying to the necessary extent. So what Gisha is saying, that Israel's policy choices have directly hinder humanitarian operations, prevent the entry and distribution of sufficient volumes of aid, and are driving famine in Gaza, particularly in the north. They go on to say this is because Israel refuses to open additional crossings, including in the north, that it is denying access to areas north of Wadi Gaza for humanitarian agencies, that it is refusing to allow humanitarian agencies to purchase goods directly from Israel and the West Bank, and so they have to source their supplies further afield in Jordan or in Egypt, and that increases costs, but also the logistical hurdles. That it is blocking commercial trade via the Kerem Shalom crossing further south in the Gaza Strip, and that prior to October 7th, 91% of the goods entering via Kerem Shalom were for the private sectors, and most of them were purchased in Israel or the West Bank. That it is failing to meet its obligation to secure a safe zone, to conduct effective, what's referred to as deconfliction for humanitarian convoys, and to ensure the safety of humanitarian staff, again, particularly in the north of Gaza. And it is failing to disperse obstructive Israeli protests that take place occasionally at a couple of the crossings. And finally, that it is refusing to restore the supply of electricity that is purchased by the Palestinian Authority from Israel's electric corporation, and that was cut off on October 7th. And as we know, it also limits the entry of fuel. Israel said that that is done primarily for security reasons, but that obviously has an effect on critical civilian infrastructure as well. And finally, that it is denying visas to humanitarian staff, right? So if we look at this picture in its totality, it casts doubt, at least in some people's mind, as to whether Israel is meeting not even simply its positive obligation, but even the negative obligations that it had since October 7th. So I want to end finally, with just highlighting the wider picture around the legality of occupation, and then we'll kind of be very happy to take questions on any of these issues. So about a year and a half ago, the General Assembly of the United Nations requested the International Court of Justice to render an advisory opinion on the following two questions. The first is, what are the legal consequences arising from the ongoing violation by Israel of the right of the Palestinian people to self-determination, from its prolonged occupation, settlement, and annexation of the territory occupied since 1967? That includes measures aimed at altering the demographic composition, character, and status of Jerusalem, and from adopting related discriminatory legislation and measures. So the first question is, what are the consequences of all of these violations of specific elements of the law of occupation? And I think it is fair to say that many international lawyers, if not most international lawyers, would agree that violations of those detailed elements are occurring in the West Bank and East Jerusalem, and arguably to certain extents in Gaza as well. But the more difficult question for the court, and the one that in some ways would be a very radical one for the court to answer affirmatively, is the second question. The court has also been asked, how do these policies affect the legal status of the occupation as a whole? And what legal consequences arise for all states and for the UN from this status? To put it simply, what the second question is asking, have we reached a point after 57 years and with this mammoth kind of frame of violations of specific parts of the law of occupation, have we reached a point where we can say the entirety of the regime is now illegal? And if the entirety of the regime is illegal, then the demand that was put forward by the state of Palestine in the proceedings before the ICJ is that the ICJ declared that the occupation should end fully, immediately, and unconditionally. In other words, not as part of an agreement. Now, we all know that politically, this sort of thing won't happen, right? I think that prediction I'm happy to make. There won't be an unconditional, full, and immediate end to the occupation. But the consequences of the International Court of Justice finding, and unlike the genocide case where the decision on the merit may take 4, 5, 10 years maybe, the decision on the advisory opinion may come later this year. And if the International Court of Justice answers the first question in the affirmative, and then proceeds to answer the second question in the affirmative, that has enormous consequences for the operation of other countries, for the operations of the UN, for the lives, I would say, of Israelis generally, and in particular of those who live in the West Bank. And so I'm just flagging this, since we are talking about the occupation, and since we are talking about the elephant in the room, we have moved in some sense from dealing with specific violations of the laws of occupation by Israel in its operations to a much deeper, troubling question, one that the court and the international community never faced, which is, can we say an entire regime is now deemed to be illegal? I'm not going to make a prediction on that particular question as to what the court is going to find out. It's very difficult to know because it's so unprecedented. But I think it illustrates the depth of the challenge that many of us on the call who are Israelis and others now face in relation to Israel's prolonged occupation going into, as I say, its 58th year in the near coming June. So I think I will end it there on this note, and I'm sure that provoked a whole host of queries or challenges or disagreement, and I welcome all of those. So thank you.
Thank you, Ruvi, for this amazing overview. Shall we open the floor to some questions? You may raise your hands or write them in the chat box.
Stunned everyone.
Confused, I would say.
Gal, you want to come in?
Okay, I have many questions. Let me start with one. So I was a bit confused at the end of your lecture. So because at the time before October 7, you said it was controversial whether it considered to be occupied or not occupied. Okay, you said it, but then my question, I guess, is right now there is a situation of war, and what is the, I mean, how it's considered to be, is an occupied territory during a war still considered to be occupied, or a non-clear occupied territory during a war? Because, okay, there is a presence now, but it's during a war. It's not, okay, I'll say it in English, it's not shitur, it's fighting, right? It's a war. So does it have a different legal aspects then, or does it still consider to be occupied, or is it different? I don't know.
Yeah, no, that's a really excellent question, and I think it is a challenging one. So I think the overall answer in international law is that actually a situation of occupation is one of the typesets, right? So one in the typology, one type of an international armed conflict, or a conflict between states, is actually defined in the additional protocol to the Geneva Convention as a situation of occupation. And it, in some sense, the question for the drafters of the convention was the opposite, was to say, can we have an occupation even if it's not resisted at all, right? So we know that the Nazis, for instance, took over certain countries in the late 30s, early 40s without resistance, right? So there was no, those countries just decided that resistance is futile, right? And what the drafters of the Geneva Convention wanted to say is that actually that shouldn't be the test, right? So the test is, do you have a hostile army that is effectively controlling your life? You don't want it. You haven't invited it. Your own army can't protect you, or won't protect you, is unable to protect you. And so whether you resist that occupation or not doesn't change the fact that there is one. Now, you're asking about the flip side situation, right? You were saying, can we say Israel has fully established itself, for instance, to the level that you can say Russia has now established itself in certain areas in eastern Ukraine, Donetsk and Luhansk, or back in 2014 in Crimea, where there is no resistance at all. And so in those situations, obviously, we've got an occupation in its fullest sense. And you can probably also look analogously and say, a few days after the start of the Six-Day War in 1967, there was no longer resistance, right? So in the West Bank, in Gaza, in the Golan Heights, in the Sinai, Israel was clearly occupied. Whereas in Gaza, the fighting continues. So I think the answer to this is the functional approach, I think, is actually very useful here, because I think it illustrates what we can expect Israel to do, right? So I don't think anyone, even today, in the north of the Gaza Strip, where there is no governmental Hamas presence above ground, right, where nothing can move on any road without Israeli authority, when no aid can come in unless Israel approves it, when no bakery can operate unless Israel allows it. It's still the case that I don't think we would expect Israel to overtake immediately the authority or the responsibility for providing education or for providing health in the fullest sense, right? Or providing welfare to the 300,000 or so Gazans who remain in the north. I think we would still apply a form of a functional approach where we would say the sort of things that Israel clearly can exercise are now greater than the sort of things it could have exercised before October 7th, because it's present and because no one else is exercising those powers. So there's a vacuum, and that vacuum has to be filled. And the reason it has to be filled by those who can exercise that authority is because otherwise the protected population, right? We've got 300,000 people living in the north of the Gaza Strip, would be left without anyone providing for them. And that can't be right? So international law says whoever's controlling has responsibilities. And my own view is that is not just legally right, that is probably morally right. Israel obviously tried to get as many people to leave the north of the Gaza Strip and move south. And he did it in ways which, you know, fall beyond the remit of this particular talk, but I have my critiques of. But it couldn't force people to leave because it had no right under international law to do so. And so even though most people did leave, 300,000 or so didn't. And they are there and they need provision. I think in the south of the Gaza Strip, the situation is more complex. I think it's obviously very difficult, for instance, to say Israel has control over Rafah. By definition, it hasn't entered it, so it doesn't. It has some control over certain other areas in the south, but probably not to the same degree as in the north. And so my view is, to repeat, it's the question of what authority it has, whether it's able to exercise it, whether it does exercise it as a matter of fact, and on that basis, ascertaining what we would expect it to do. So I hope that makes sense.
Ruvi,
Yeah,
I remain confused.
right. Sorry.
At what stage did Israel stop being the occupier of the Gaza Strip, if at all, in the eyes of the law?
Mm.
And if we never did, then Gal's question is very relevant. What has changed? If it didn't, then what you're saying about the north and the south, where does the difference lie? But again, in the eyes of the law, regardless of my own opinion, whether we are occupying or not.
So, yeah, so the reason the answer is complicated is that the Gaza case is a complex case, right? So let's kind of take us back, not even to 2005. Let's take us back to 1993, right? Okay. So in 1993, so 67 to 93, there was no Palestinian Authority, right? Israel was doing everything, right? It had some local governments. So there were Palestinian mayors elected. We all know in the West Bank, the Jewish underground tried to kill a few mayors, Palestinian mayors, in the early 80s. So there was domestic terrorism against some local representatives, but overall, Israel had control over all aspects of Palestinian life. The Oslo agreements have meant, and the Gaza Strip, except for the settlements, were all under Area A, under the Oslo agreement. So they were all under full Palestinian civil control. And so to a large extent, certain elements of life, even before the disengagement, between 94 and 2005, were not really exercised by Israel. Israel wasn't really providing welfare, wasn't really providing education, wasn't really building roads inside Gaza City. The Palestinian Authority was doing this, but Israel was still undoubtedly, in the eyes of anyone in the international community and under the eyes of the law, the occupier of the Gaza Strip as a whole, right? So to some extent, some of these functions that Israel was technically no longer able to exercise because it had no boots on the ground after the disengagement, it didn't exercise to begin with, right? And some of the other functions that it exercised before the disengagement, it continued to exercise. So before the disengagement, it had control over the population registry. Israel decided if a baby gets registered or not, if somebody is able to appear as a resident of the Gaza Strip or the West Bank, if they're able to leave the Gaza Strip to the West Bank and back. Israel was selling electricity to the Gaza Strip. Israel was controlling the passages to the Gaza Strip before 2005 and after 2005. And so the gap between what Israel was doing in the Palestinian areas, not in the settlements, but in the Palestinian areas before 2005 and after 2005 is much smaller than I think we have been accustomed to believe. The reality was that the Palestinians were running their own civil affairs even before the disengagement. They were just seeing Israeli soldiers much more often than they saw them after 2005. After 2005, they saw them whenever there was a conflict, but not on a daily basis. And so the reason the answer is complicated, the reason I think the international community, in my view, rightly, was not willing broadly to accept the Israeli position as expressed by the prime minister, that we left, so we now have no responsibility for Gaza after 2005, is that simply wasn't true. Israel continued to have responsibility for the things that continued to matter to Israel, and it no longer had responsibility for things that it didn't really exercise prior to that date as well.
Excellent. Excellent. And are we then saying that after 2005 and before the 7th of October, we as an occupier were fulfilling our legal obligations as an occupier in Gaza or
Well,
not?
so I think the answer is because there was a de facto government in Gaza. Hamas was running the civilian affairs of Gaza. So Hamas was utilizing the UN agencies, UNRWA and others, which anyway provide, even when Israel was in control, provide large or is responsible to the welfare and health and education of large parts of the Palestinian population in Gaza. Because all of that was happening between 2005 and October 7th, then there was no expectation that Israel would in any way undertake those duties. It also was, I think Israel would have been in a good position to say, we don't have an infrastructure inside the Gaza Strip to be able to provide these services, even if we wanted to. So in other words, in those years, there was no need for Israel to provide food or medicine or that, because someone else was doing it. They may have been stealing money that was intended for the humanitarian needs of the civilian population. But in the end, there were 18 functioning hospitals in Gaza. There were bakeries baking millions of breads a day. There were universities, not anymore, in Gaza. So Gaza was a functional place, right? It wasn't a wealthy place, but it was a functional place. So I think what changed after October 7th is that large parts of Gaza are not functional at all, right? And they're not functional at all, not because of a natural disaster, right? They're not functional at all because of the consequences of Israeli operations. And Israel now does have boots on the ground, right? It does have physical presence. So those are the things that have changed, right? So the overall legal framework may have not changed dramatically. So if that is the gist of your point or your question, I agree with that. I think it's not a binary. It's not the case that Israel had no control over Gaza and now has full control over Gaza. It's the case that Israel had some control, and in some areas, someone else was doing the job. And now no one else is doing any job, and Israel has more control, and so has more responsibility and more obligations. That's how I see it. It's a spectrum, and we've moved alongside that spectrum. I hope that makes sense.
We have two questions on the chat.
Yeah. So let me answer those questions. The first is, can we say a few words about the ICC arrest warrant? So I prefaced my talk by saying Palestine as a state, as a non-member state of the UN, has joined the ICC, has signed on to the ICC Rome Statute, and the previous, in fact, prosecutor of the International Criminal Court has recognized that Palestine can be a member, and as a result, that there is jurisdiction for the International Criminal Court in the Palestinian territories, and that includes Gaza. But that also means that actions of Palestinian nationals, namely actions of Hamas, Islamic Jihad, and others on October 7th and since October 7th are also subject to the jurisdiction of the ICC, even though they took place or are taking place largely outside Palestine. They're taking place inside Israel, and Israel is not a member, right? So because Palestine joined the ICC, it would be possible to issue arrest warrants against Hamas and Islamic Jihad operatives. Otherwise, it wouldn't be. I think that's an important point to note for people who vilify or otherwise think about international institutions like the ICC in a way large parts of, I think, sadly, of the Israeli public does. The more critical question is, will there be arrest warrants, right? So I'm not a prophet, and I'm not going to predict. But what I will say is that there are two fundamental questions for the prosecutor. The first is the gravity of the actions such that justifies arrest warrants and potential prosecutions, ultimately convictions. So the International Criminal Court doesn't deal with cases where there might be violations, but they are of a very minimal nature, because it's ultimately an international court that wants to deal with the most serious crimes. My own view is that both October 7th and many of the things following October 7th certainly meet the gravity test. So I think the prosecutor is likely to reach that conclusion as well. The more difficult question is the second question for the prosecutor, and that is the notion in international law of complementarity. So it's the idea that the states should have the opportunity to conduct investigations first, and only if a state is deemed not to be effectively investigating its own operations, its own infractions, its own potential violation, only then does an international court step in. So there is a first, you might call it a first chance given to the state to try to do its own. Now, we all know Hamas obviously is not investigating itself. So I think the question of complementarity on the Hamas end doesn't exist. This is why I think the likelihood of arrest warrants against Hamas operatives is high. I think the question for Israel is a more complicated one. And again, I don't want to get into very specific details. I will just say cautiously that if I were an Israeli senior leader, I wouldn't use the language that Israeli senior leaders are using, including language that some ministers have been using today, because that type of language certainly provides people who read that language a basis for thinking that at least the mental component, the mens rea of some of the offenses under international criminal law is met. And so I'll leave it there. I won't go further, but I think I'm sending a fairly clear message there. And they may have already dug their hole or their grave, their legal grave, by now, but time will tell, as I said. The second question was, what effects do the Palestinian repeated declaration of independence and UN membership have on the question of control and occupation? Can they simultaneously claim statehood and claim Israel is responsible? Well, the short answer to this, of course, is yes, in the sense that Belgium did not cease to be a state when it was occupied by Nazi Germany. Poland did not stop being a state when it was occupied partly by the Nazis and partly by the Soviets in 1939. And more generally, you can have parts of a state occupied. There is a part of the Syrian Arab Republic that is occupied by Israel in the Golan Heights. There was a part of Egypt that was occupied by Israel. So I think there is a serious question in international law, which this talk did not address, as to whether Palestine meets the conditions under international law of already being a state. That's a serious question. There are strong views on either side from a legal an analytical perspective of whether they meet those conditions are historically set in the Montevideo Convention back from 1933. I won't go into those details here. But that is a separate question, right? So the question whether there is a Palestinian state at the moment that is under occupation is separate to the question of whether the Palestinians living in the West Bank, in East Jerusalem, and arguably in Gaza are under military occupation. That second question is a factual question. Is there a hostile army having control over their lives in the way that international humanitarian law defines as occupation? I think the answer is yes. In all of those territories, to differing degrees, to a full degree in the West Bank and in East Jerusalem, to a lesser degree in Gaza in different areas. And so the question whether Palestine is or isn't a state already within the meaning of international law is a separate and doesn't affect that analysis of the question of occupation. So I hope that makes sense. And then the final question there was, what legal powers can the court or international community to enforce cessation of Israeli occupation? So I'm assuming this refers to the ICJ if it were to render an advisory opinion. So the short answer is that directly, because it will be an advisory opinion, it won't have any enforcement powers. But, and there is a very important but here, if there is an advisory opinion that even finds in the affirmative the answer to the first question, so the question on the violations of different elements of international law in relation to the prolonged occupation, to the regime in the West Bank, to discriminatory laws that may amount to apartheid, to demographic changes in Jerusalem and the like, then the General Assembly may adopt a resolution which won't have an enforcement power, but the Security Council can then, on the basis of that advisory opinion, instruct states to operate in a certain way. Now, we all know that the US perennially has been blocking resolutions that would have specific legal effect in relation to the Israeli occupation. But that may change, right? And if there is actually a affirmative decision by the International Court of Justice to that effect, and if there is a different US administration, then that reality may change. It's also the case that individual states may look at the International Court of Justice's advisory opinion and say, on that basis, we now believe under our own domestic law that we are required to, for instance, seize trade with Israeli settlements or to block entry of Israeli settlers to our territory, or to stop trade even with any company that has any business in the West Bank, even if it's not operating from within the West Bank. And they might ground those types of decisions in their domestic systems on such an advisory opinion. International organizations like the European Union may take that position because they respect the International Court of Justice's position. I'll just say anecdotally, perhaps not anecdotally, that of the 58 countries that appeared before the International Court of Justice in the advisory opinion context, only two, the other one being Fiji, so Israel and Fiji, were actually contesting the legal arguments around the legality of occupation. The American position was that the court shouldn't hear this case. So America took it didn't really engage with the merits. So if you want, you can count the US as a third country. But the other 55, including Britain, including France, when it came to the question of the merits, they may have not liked the fact the ICJ is hearing the case, but on the merit, they didn't present a legal position that refuted the case that was put forward by by the Palestinians in the court. And so, as I say, I'm not going to predict how the court decides this case, but I can only say that the Israeli position was in you know quite resounding minority within that case. So I think those were all. There was I think a follow-up question was, can you foresee if Israel ignores international law, some sort of a military involvement? Look, so I think that follows from what the Security Council would be doing, right? So if the Security Council adopts a resolution, for instance, that calls on Israel to evacuate settlements or to do something else in the West Bank that follows directly from an advisory opinion, and if Israel then defies that resolution, then some sort of an enforcement may happen. But this is very speculative, because in some sense, this is all contingent on the Americans allowing any operative decision of the Security Council to pass. At the moment, that doesn't look likely, but you know, we never know. I mean, I will just say, for those who haven't followed the news today, this will date this presentation. There was an interview that the former American president, potentially future American president, Donald Trump gave to, I think, Newsweek or Time magazine, where he says he's not ruling out stopping military aid to Israel, for instance. So where America will find itself after the November elections, I think, is anyone's guess, whoever is the president. And if America changes its position, then I think Israel will find itself in a much more challenging state in the Security Council.
Orit, you're muted.
Yeah, Ruth, you're muted, and I think we've
I
gone past
said-
the quarter past.
Yeah,
so
I said I was conscious of time, and we have run
Yeah.
out of time. So thank you again, Ruvi. Thank you again, Ofer. Many thanks to Jenny, who couldn't join us, but was busy organizing today's Zoom event. I placed a questionnaire in the chat for everyone to please respond to, so that we can continue to improve and innovate. There weren't as many people as we had hoped on today's Zoom conversation, due to the fact that it's the end of the Pesach holiday and many people are away, which is why we have recorded the session. So thank you those who made the time to join us today, and we hope to see you in our next Zoom session. Thank you very much.
thanks, everyone.
Good night.
Thanks, everyone.